So welcome everyone to today's webinar on vaccinations and the workplace. My name is Chris Drinovz. I'm an employment lawyer. I'm the head of the Employment and Labor Practice Group at KSW Lawyers. I'm also a director at the Chamber of Commerce, and I'm very happy to be here this afternoon to share some insights with you and have a conversation with you about a very hot and important topic in the workplace. So thank you for taking the time out of your day. Some housekeeping to start, because we're in technically a meeting Zoom format, I would ask everyone to keep themselves muted throughout the presentation. Once I've gone through my presentation, we'll have a Q&A period, during which time you can ask your question, unmute yourself and ask your question. There's also a chat box available if you wanted to punch in a question or comment during the presentation. I'll have a look at the chat box after as well, and we can go through any questions there. Okay, so let's get started. So there's no question that COVID-19 remains on the top of everyone's minds today. January 25th marked the one-year anniversary of the first case of COVID in Canada. And I think everyone can say that their lives have changed drastically since that time. There's lots of good news and encouraging news right now. We've been trending down in British Columbia in terms of the numbers of new cases, active cases, and hospitalizations, which of course is encouraging. BC has rolled out its 4-phase immunization plan, which contemplates everybody in the province being vaccinated by the end of September 2021. And a correction to the slide, I believe we're currently in phase 2 of the rollout plan. Phase 1 was healthcare and long-term care workers. Phase 2 contemplates vaccination of seniors and more vulnerable people. There's been about 155,000 doses already administered within those 2 phases, and I understand that's going to be increasing quite significantly in the next month or two. The rest of us are, of course, waiting patiently, with the exception of the great Canadian gaming CEO who stole off to the Yukon to get his dose before the rest of us. So that's a separate topic on executive misconduct that will be for another day. There is some news of shutdowns and logistical delays in Europe and threatening of the vaccine supply. We've been assured by the powers that be that the current projections are still realistic. But of course, now we have news of these variants like B117 with higher transmission rates to keep us up at night. So I think ultimately what we can take from this is COVID-19 is going to be an important issue for employers to deal with in 2021. And for that reason, it's important to stay on top of these things from a business and a legal perspective. So, coming down to the heart of this presentation, a big question on a lot of people's minds is can an employer require employees to get the COVID-19 vaccine? And I think the answer to that question is a classic lawyer's answer. It depends. Provinces and the provincial legislature has the power to require mandatory vaccination, but at this point, the government has not introduced any legislation of that sort. So in the absence of that, we have to analyze the issue based on the principles of law that we have regarding workplace policies, human rights issues, and past case precedents relating to similar issues. So in terms of vaccination policies, in the absence of the mandatory legislation that may come down the road, an employer cannot force an employee physically to get vaccinated. But they can introduce a workplace policy that makes vaccination a mandatory condition of continued employment. So there are a number of intersecting concepts to consider in this analysis. There's the employer's duty under the Workers' Compensation Act to maintain a safe and healthy workplace and to do everything reasonable within their power to keep the workplace safe for all of the workers on site or on the premises. And further to this, if an employer breaches their health and safety obligations, there can be serious penalties from WCB officers, and there could be even criminal liability for gross negligence resulting in serious injury. There's also the risk of civil liability if a customer or a patient or a patron comes to your premises and gets COVID because of negligence. All of that must be balanced with the rights of the employee, the employee's privacy rights, the employee's rights under the Human Rights Code. All of those things need to be balanced in a reasonable and proportional way when the employer is considering introducing policies. So the starting point for any sort of a COVID-19 policy is the same starting point for any workplace policy. Number one, it must be reasonably necessary for the workplace. And number two, it must be rationally connected to the workplace and the function of the workplace. So you need to do an assessment of the nature of your business and evaluate the extent to which you need to or don't need to require mandatory vaccination. What does your workplace look like? What kind of business are you? How much contact is there between employees and customers? Are you dealing with people that are coming in from out of province or out of country? That kind of stuff. And I think that the important question is, do your existing measures now, such as mandatory masks or regular COVID-19 symptom screening, are those sufficient to meet your health and safety obligations? Or do you need to introduce something more intrusive, like a mandatory vaccination policy? I think it's obvious in certain industries that mandatory vaccination would be justified. So sectors like the healthcare sector, obviously long-term care, homes or organizations that are dealing with senior citizens or vulnerable persons, and possibly the education sector. Those are sectors where almost per se, it makes sense to have mandatory vaccination. And we can look at influenza or just the regular flu as kind of a guiding example to that. Like in the healthcare industry, BC has had an influenza prevention policy in place since 2012. And that basically requires all healthcare workers to be vaccinated against influenza or to wear a mask in patient care areas through the flu season. So those policies have been in place in BC, and they've been upheld by courts and arbitrators as reasonable and necessary and rationally connected to the workplace. And in the cases where those types of policies have been challenged, the decisions have been made on the basis of scientific evidence that vaccination or wearing a mask actually does reduce or prevent transmission. And so therefore that's a reasonable policy to have in those particular industries. And I think looking at the science relating to COVID would make a strong case for mandatory COVID measures in those industries, given the data we have so far on the effectiveness of the vaccine being up to 95% effective, and the fact that COVID-19 is much more severe than the regular flu. The risk of death is much higher, particularly in vulnerable demographics. So there has been some case law that we can use as guidance. There was a recent decision where an arbitrator upheld the employer's decision to impose mandatory COVID testing at a retirement home. And I wanted to quote the arbitrator's comments here because I think they're very important. So the arbitrator said, "What is known is that COVID is highly infectious and often deadly for the elderly, especially those who live in contained environments. In my view, in one way is the intrusiveness of the test, a swab up your nose every 14 days, against the problem to be addressed, preventing the spread of COVID in the home. The policy is a reasonable one. While the home had not had an outbreak, I agree entirely with the employer that given the seriousness of an outbreak, waiting to act until that happens is not a reasonable option. So this kind of demonstrates the weighing, the balancing act that the decision makers will do. They'll look at, how much of an intrusion is it to carry out the policy versus, what is it preventing and what's the gravity of the risk. And so this particular case applied to a testing policy, but I think a similar analysis would be done in terms of a mandatory vaccination policy. And I think, a vaccination is more intrusive than a test, but particularly in something like a care home, that step would be proportional to the risk that's being mitigated against. So for those that are outside the healthcare sector or in non-public facing settings, like an office, requiring all of your employees to get the vaccine as a mandatory measure may be more difficult to justify. And in that scenario, we could see a legal challenge saying that the policy is no longer reasonable and no longer necessary to achieve the objectives of health and safety. And so, apart from the legal side of it, there's also non-legal considerations. A mandatory policy is obviously inherently invasive. It's in essence, you're asking an employee to undergo a medical procedure. And anytime that you mandate something or make it a requirement, you're going to have employees that disagree. You're going to have people that protest that. It's just the nature of us as humans and what you see in the workplace. So if you can implement less intrusive means to achieve the same result, i.e. a health and safety result, some examples could be as follows. You could encourage employees to vaccinate as opposed to outright requiring it. We see some examples in the US, such as the large grocery chain Kroger. They're giving employees $100 bonuses to get vaccinated. Some other smaller organizations are giving 4 hours of time off or 2 days pay. So instead of doing a mandatory policy, consider whether you can do a voluntary policy and have everybody sign up under that, and maybe even giving an incentive to do it. If you don't have the means to provide an incentive, I think education and enabling is the best alternative. So sending out reminders, sending out information about getting vaccinated, or even setting up a free vaccination at your workplace, the appropriate time to make it easy for the employees to do it. If you do an evaluation and you feel that those alternative measures are just not going to protect your workers and your clients or your patients, then and you do implement a mandatory policy, you want to follow all the steps that you would follow for any other policy that you want to enforce. So it needs to be clearly drafted in writing. It needs to be communicated properly to all of the employees it's going to apply to. You need to ensure that there's proper training and communication around the policy so that everybody understands it well in advance of when it's going to come into effect. So, as I was saying before, the majority of your employees are likely going to be compliant and reasonable, whether you do a voluntary policy or a mandatory one. But there's always going to be that one employee or that group of people that object just for the sake of objecting, or because they hold some belief that's inconsistent with your culture. So they've done some polling on this recently, and a recent poll 60% of British Columbians said that they would get the vaccine at the earliest possible opportunity. In that same poll, 8% of British Columbians said outright that they would not get the vaccine. So I want to be clear to everyone, if you have an employee that refuses to get vaccinated or fails to follow your COVID-19 policy, you can terminate that employee. It's not illegal to do so. Whether you terminate them for just cause without severance pay or terminate them without cause depends on situation and depends on the circumstances. If you have a solid employment contract that only requires you to give an employee a certain amount of notice or pay, the least risky situation is to simply dismiss without cause. If you feel that this employee is going to be an issue and they've made clear that they're not going to be vaccinated and that's going to be a problem for you and the workforce. You may also want to consider, before you go to termination, is there some alternative that everybody can live with? So can you offer that person remote working? Can they continue their remote working arrangement for a certain period of time? Is there a non-disciplinary alternative where they take an unpaid leave or use up the rest of their vacation or something like that? You should always explore those alternatives before you go to termination. But if you have to terminate, have a look at your contract or your collective agreement, and you can go ahead and do that. In certain situations where there's been some intentional act that's caused a safety issue at work, or a blatant disregard for policy that puts other people at risk, you can consider terminating for cause. And we've seen a couple cases in the unionized environment where arbitrators have really upheld the employer's right to terminate employees who fail to comply with COVID-19 workplace procedures. So I'm going to give two examples. There was one case out of Pearson International where a screening officer was terminated for failing to self-isolate after being tested for COVID, which was a breach of the employer's policy. The policy said that if you get tested, you need to self-isolate until you get the result. This employee ignored that and actually went to work on the same day that she had her test. It turned out the test came back as positive, and when there was an investigation on this, the employee denied that she'd actually gone to work that day. And her excuse was that she felt fine, and so therefore she felt it was okay to go to work. The employer, once they discovered all of this, they terminated the employee for just cause. The union brought a grievance, and the arbitrator ruled that the termination was justified. And the arbitrator focused on the employee's knowledge of the COVID-19 guidelines and the potential impact of her actions on not only the other employees, but the people that she was coming into contact with by virtue of her position. And I've quoted from the decision there. It says, "The griever, who was the employee, put at risk by returning to work her colleagues. She also put at risk other persons working at the airport with whom she came into contact. She also put at risk the general public flying from Pearson, and in turn, persons with whom these passengers would have had contact at their destination." The arbitrator went on to say that actions of the employee were a clear violation of the employer's and public health guidelines. Her claim of not feeling sick is absolutely irrelevant. She was required to isolate, as she knew, for the safety and health of others. She chose not to, thereby putting countless others at risk of illness or death. So again, we see the employer being justified in taking strong action in these circumstances, and the arbitrator really upholding the right to do that and coming down with some strong language in favor of health and safety. There was a second case involving a construction employee who actually attended work while experiencing symptoms of COVID, which was also in breach of the employer's policy. He'd been directed not to attend work until he was cleared by the company's nurse, but he did, and he attended a pre-work team meeting while he was symptomatic, exposing his coworkers to potential infection. This was an ongoing thing. He had 2 previous safety violations, and so he was terminated for cause. Again, the arbitrator came down in favor of the employee, saying, taking into consideration his previous safety issues, his deliberate and cavalier attitude toward the COVID safety risks, he represented both to his coworkers and to the company. They said his actions were unconscionable, unreasonable, and totally unacceptable. And so for that reason, he couldn't be trusted to avoid engaging in unsafe conduct in the future. So these are 2 union environments, and the considerations are always a little bit different. But I think the mentality of these arbitrators would be mirrored in the mentality of any judge that's looking at this kind of a situation. And I think the decision makers are going to take a no-nonsense approach to any employee misconduct and ignorance. And so when you do have your policies in place, you can be confident in enforcing them as long as they're reasonable. You know, if there is a flagrant breach like these 2 cases, termination for just cause without compensation may be appropriate, and it may show the workforce that, you know, you're serious about protecting them. So I'm going to talk a little bit now about human rights considerations. If you are going to be rolling out policies or considering action against an employee for breach of a policy, it's essential that you consider your obligations under the BC Human Rights Code before taking these actions. So human rights legislation requires that exceptions or accommodations in the implementation of workplace policies be made for those who cannot meet the requirements of the policy due to certain protected grounds. And those grounds are listed in the Human Rights Code and include things like medical disability, religion, place of origin, gender, all of those kind of personal characteristics are protected grounds under the BC Human Rights Code. And so to give you an example of how this might come up, I'm dealing with a case now where my client is in the manufacturing industry and has about 100 people in the plant. And he introduced a mandatory mask policy for all the workers in the facility. There was one holdout employee who simply refused to wear the mask, but didn't really say why, didn't raise any concerns about medical issues when the policy was implemented, but continued to take the mask off, which caused many issues for those that were working nearby. And so ultimately, the employer disciplined this individual for non-compliance with the policy and suspended him. And the next thing we know, we've got a letter from a lawyer saying that this person had a disability that prevented him from wearing a mask, and there was a threat to bring a human rights complaint for discrimination. And of course, this was the first that the employer had heard about a need for accommodation, and those concerns were not raised when the policy was introduced. But we have to deal with the issue nonetheless. And so, you know, if you have any, if there's any indication from an employee that they're unable to comply with the COVID-19 policy, whether it's wearing a mask or getting vaccinated, you need to go talk to them right away and determine what are the reasons for the refusal or the need for an accommodation. You know, is there a legitimate medical reason why somebody cannot meet this policy? And once you've really flushed that out with the employee, you can evaluate, is this truly a protected ground under the Human Rights Code? And what are my obligations to accommodate this person if that's the case? So in terms of vaccination policies, you may encounter objections based on legitimate medical grounds. Employees may have an allergy to ingredients in the vaccine, or the person may have an autoimmune disease or another pre-existing medical condition that legitimately prevents them from getting the vaccine. You could also see objections based on protected religious beliefs, such as where the employee may only believe in faith-based healing and won't take the vaccine for that reason. So in these, I would say, rare situations where there are legitimate grounds for objection, either medical or religious or other, you need to carefully evaluate those reasons and get advice about whether they truly are protected and how you're going to deal with them in terms of offering an accommodation. The duty to accommodate is a complex concept, but at its heart, an employer needs to take all of the steps to accommodate an employee under one of these protected grounds up to the point where it reaches an undue hardship. And an undue hardship is quite a high bar. And so if you can accommodate an employee relatively easily from a financial or logistical perspective, you do have an obligation to do that under the Human Rights Code. So if one particular employee has one of these legitimate objections, you need to explore accommodations that make sense for your business, such as a reassignment of duties, having them work remotely, maintaining existing measures such as mandatory masks for that person or where that person works, even if all others have been vaccinated. Like I said before, the truly protected human rights objections will be rare, where an employee simply refuses to follow a policy because of personal preferences or concerns about the safety or effectiveness of the vaccine. Those concerns do not garner the protection of the human rights legislation. So absent convincing and compelling reason that connects the employee's concern to the protected ground, a general objection or personal preference would not displace the policy, and you would have the option to take disciplinary action if the employee didn't meet any of those protected grounds. There was a case from Ontario in the 2000s where a nurse working at a federally regulated care facility refused to comply with the facility's mandatory influenza immunization policy. And her reasoning for that was she'd never been sick with the flu. She felt she had a strong immune system, and she had faith that she didn't need the vaccine. Not faith in the religious sense, just faith in her own immune system. And so the employer, that was not satisfactory to the employer, and they said, we need you to follow the policy. She refused, and so the employer exercised its rights to terminate her. She brought a complaint under the Canada Labour Code because it was a federal employer, and said that the dismissal was unjust, that the employer didn't have the right to terminate her in those circumstances. And it went all the way through to a trial, and the adjudicator held that the employer's decision to impose the vaccination as a mandatory term of employment was in fact reasonable, and therefore the complaint was dismissed. So again, we see in the scenario of a care facility, a mandatory policy being held as reasonable. So my takeaways on the human rights side, if you do come up with a policy, whether it's mandatory or voluntary, you want to include a provision that states that applicable human rights legislation will be followed. You want to give lots of advance notice to people as to when the policy is coming into effect, and give them a means and an opportunity to express any objections or concerns under human rights legislation, so you can then do an evaluation and make sure you're fulfilling your duty to accommodate. If you are faced with an objection, a refusal, a complaint, do a careful investigation of that, make sure it's well documented, and ascertain what are the true reasons for this refusal. Is it personal preference, or is there a legitimate medical reason why this person cannot be vaccinated, and you can require proof of that, whether it's by way of a doctor's note or something else that's satisfactory to you. And once your duty to accommodate is triggered, carefully evaluate what you can do to accommodate that person and whether that would constitute an undue hardship for you. So if you get to the point where you feel you simply cannot accommodate the person because of the nature of your workplace, it's a good idea to get some advice before you decide to let them go. So before we go to questions, I'll make a few comments on privacy. So generally speaking, employers have a right to obtain personal information from their employees, as long as it's for the purpose of managing the employment relationship and as long as it's connected to reasonable employment objectives, which could include ensuring workplace safety. So the balance between workplace safety and employee privacy really depends on the circumstances. And it's been shifting ever since the start of the pandemic. For example, in 2019, employers would never have considered screening their employees or customers with a daily temperature check. This is now, of course, a common practice across all of Canada. So if you do implement a mandatory policy or a voluntary policy or some sort of a vaccination verification program, you have to be mindful of your obligations to protect the personal information that you obtain through the administration of that program. So there is some guidance out there for employers on privacy issues, and I will send around the slides for this presentation when we conclude. But there's a very good advisory document from the Saskatchewan Privacy Office, which obviously relates to a different province, but the principles are very similar. And we'll put a link to that document in the slides, which you can have a look through. But I encourage everybody to browse through that document because it provides some excellent guidance on the employer's obligations insofar as privacy is concerned when it comes to vaccination and COVID-19 policies. Some of the key points that I've gleaned from the guidance document: number one, employers are not prohibited from asking employees about their vaccine status or even asking for proof of vaccination. And one of the principles of privacy law is you want to collect only the information that you need to achieve your objectives. And so if you're satisfied that verbal confirmation from your employees that they've been vaccinated is sufficient for you to be confident in that, then that's the least intrusive method of collecting information. The other side of that is you could ask them for actual vaccination certificates and keep those in the employee personnel files, just like you would with any other employee personal information. Again, going back to policy, if you are going to be implementing a vaccination verification program, you want to have a clear policy outlining the fact that you'll be collecting personal information through that program and outlining how that information is going to be handled and ensuring your employees that information will be protected, just like any other medical information you would receive as part of an accommodation process or as part of a medical leave process. The final comment I'd make on privacy is, again, just like other sensitive information, it should only be shared with those who need to know. There should only be a few people in the organization that have access to that kind of information, and it should be stored in a place that's safe, and it can be destroyed when it's no longer needed. So those are my comments on privacy. Like I said, we'll share the slides after the presentation, and I would encourage anybody, if you have any follow-up questions, to connect with me on LinkedIn or send me an email. If you are a member of the chamber, I'm happy to have a quick 10 or 15-minute call with you free of charge to discuss these issues. It's something that's really important to me, so I'm happy to do that. And with that, we will have some time for questions. I don't see that anybody has asked anything in the chat box. So if you want to ask a live question, feel free to unmute yourself and ask your question. Okay.
Hi, Chris, it's Colleen.
Hey, Colleen.
So I did have a quick question regarding that. When we talked about employees and the health risk to the office, so office employees, if you're required to send your employees off to other places or travel and such, and vaccines are required for those purposes, how does that all work if the person's decided they're not going to get it?
Yeah, so that's a scenario where I think vaccination would become a mandatory term of employment, because that employee cannot fulfill their core duties without getting the vaccine. So in that sort of a scenario, if there was a refusal, you could consider, is there another position you could move the employee to without that being an undue hardship for your organization, or you could say this is a requirement of the position, and if you're not willing to do it, and you're convinced that it's not for protected human rights reasons, that employee wouldn't be able to fulfill that role anymore, and so that you would have to terminate them, or come up with some sort of a severance package. Now, if that employee had a legitimate medical reason for the refusal, that would engage the duty to accommodate. So you would necessarily have to evaluate, can we put them somewhere else? Can we have them not go on those trips for a period of time? And again, that's kind of a case-by-case evaluation based on the size of the organization, what the other employees are doing, et cetera, et cetera.
Thank you.
Okay. If there's no other questions, I think we will conclude the webinar. Thank you, everybody, for joining us this afternoon. Have a wonderful day, and look forward to seeing you all soon. Bye for now.